be alleged positively, precisely, and distinctly, and as briefly as is consistent with a clear statement. Quote. The aforementioned provisions contained in the first schedule to the Electoral Act 2022, as well as the Federal High Court's Rules 2019, state the mandatory requirements of pleadings in election petitions. The requirements for clarity and precision of fact required by paragraph 4 of the first schedule to the Electoral Act means that averments must not be vague, ambiguous, or unclear, leaving room for speculation or conjecture, while the requirements of distinctiveness means that each averment must contain a clearly understandable allegation, and there should be no confusion as to the linkages between facts contained in the averments in the petition and ascertaining the allegations being made in the petition. In particular, paragraph 4 sub 1 sub d, relating to the facts of the petition, the grounds on which it is based, and the relief sought by the petitioner have been severally considered and interpreted by the appellate court. In Belgore and Ahmed Supra, the complaint against the averments in the petition was that they were unspecific, generic, speculative, vague, unreferable, omnibus, and general in terms. In that case, the Apex Court specifically held as follows, and I quote, pleadings in an action are the written statements of the parties wherein they set forth the summary of the material facts on which each relied in proof of his claim or his defense, as the case may be, and by means of which the real matters in controversy between the parties and to be adjudicated upon are clearly identified. Although only material facts are required to be pleaded and in a summary form, they must nevertheless be sufficiently specific and comprehensive to elicit the necessary answers from the opponent. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which alleged electoral malpractices, non-compliance, and or offenses in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have met the requirements of pleadings as stipulated in paragraph 4 sub 1 sub d of the first schedule to the Electoral Act and or order 13, rule 4 sub 1, 5, 6, and sub 1 of the Federal High Court Civil Procedure Rules 2009, unquote. Indeed, in PDP and INEC, the Apex Court was categorical when it held those, and I quote, on whether the affected paragraphs were rightly struck out. I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling units, disruption of election, non-conclusion of election, thumbprinting of ballot papers, falsification of election results, widespread disruption, irregularities, and malpractices without providing particulars or the polling units where the alleged malpractices took place. The lower court was therefore right when it held as follows. Above the paragraphs above, in my view, are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the averments in the pleading must not be general, it must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above, and I adopt it as mine, unquote. Indeed, on the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act relating to further particulars, the Apex Court held in PDP versus INEC, Supra, that, and I quote, an application for an order for further particulars is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, and devoid of necessary particulars as the appellant's petition was in the instant case, unquote. A sober consideration of the decisions of the Supreme Court in relation to the requirements of pleadings in paragraphs 4 sub 1 sub d of the first schedule to the Electoral Act 2022, on the one hand, and the decisions of the Supreme Court on the provision of paragraph 17 sub 1 and sub 2 of of the first schedule, the Electoral Act 2022 relating to further particulars, on the other hand, shows that whilst in cases such as Abubakar versus Eraduan and Ombugadu versus Sule, the Supreme Court had held that a respondent who complains of vagueness of averments in an election petition should avail himself of the provision of paragraph 17 sub 1, first schedule to the Electoral Act, seek for further particulars or the direction of the tribunal or court. The decisions of the Apex Court, especially in PDP, INEC, and Belgore and Ahmed, have specifically held that where averments in the petition are grossly imprecise and generic, such averments will be incompetent, liable to be struck out. So also on this EPRZU. It is therefore clear that the state of the law, as could be deduced from the various decisions of the Apex Court, is that the provision for further particulars, as stated in paragraph 17.1, first schedule to the Electoral Act 2022, will only come into play where the petition itself contains material or necessary particulars. In other words, paragraph 17 sub 1 of the first schedule to the Electoral Act 2022 does not bar a respondent from applying under paragraph 4 sub 7 of the first schedule to strike out averments in a petition which are grossly inadequate, insufficient, and devoid of material or necessary particulars. This is because the operational words in paragraph 17 sub 1 is further particulars, and this means there must be some material particulars already pleaded in the petition before further particulars can be sought by the respondent. As born from the Apex Court decision in Belgore and Ahmed, PDP, INEC, and EPRZU and OT, the law is clearly settled that specifying the particulars of polling units or places where irregularities are alleged to have occurred are material particulars in an election petition. Averments in an election petition which allege irregularities and malpractices but fail to specify the polling units or places where the irregularities or malpractices occurred are bereft of material particulars, and such averments are incompetent and liable to be struck out. As specifically stated in PDP and INEC, a petitioner who has failed to state such material particulars cannot invoke the provision relating to further particulars as a sword against a respondent in order to cure the incompetence of such averment. With respect, it is a misconceived argument on the part of the senior counsel for the petitioners to state that the latter decision of the Apex Court in Ombugadu and Sule Supra, which relates to further particulars under paragraph 17.1 of the first schedule, has departed the specific decisions of the Apex Court in Belgore Ahmed, PDP, INEC, and EPRZU and OT, and several others, on the mandatory requirements for stating material facts as provided in paragraph 4.1, first schedule to the Electoral Act. Contrary to the contention of the petitioners, the decision of the Supreme Court in Ombugadu and Sule Supra has merely reiterated the legal position relating to further particulars as provided in paragraph 17 sub 1, first schedule to the Electoral Act 2020. It has not departed from the above specific decisions of the Apex Court on the materiality of specifying in an election petition polling units or places where irregularities and malpractices are alleged to have occurred. Now, a look at the averments in the petitioner's petition shows that the petitioners have only alleged various irregularities and malpractices, but failed to specify the particular polling units or specific places where the alleged irregularities and malpractices have occurred. For instance, in paragraph 9 of the petition, where the petitioners avert that, and I quote, in appropriate cases, these agents raise complaints about anomalies where they occurred and reported such complaints to designated officers of the second respondent and the first respondent, unquote. The petitioners failed to specify the anomalies, the places where the anomalies occurred, the agents who complained, and the designated officers of the second petitioner and the first respondent to whom the complaints were made. In paragraph 60 and 61 of the petition, where the petitioners allege that the first respondent, and I quote, suppressed the actual scores obtained by the petitioners by deliberately uploading blood from EC8As on the IRF in 18,088 polling units. The petitioners did not specify the polling units, but only stated that they will rely on spreadsheets containing the polling units codes and details of the 18,088 polling units, as well as the authentic results in the said polling units. In paragraph 66 and 67, where the petitioners allege that the first respondent embarked on, and I quote, massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, unquote. They did not specify the polling units where they allege there were no elections. Incorrect results that were uploaded and which are the correct results. Again, in paragraph 68 to 71, where the petitioners allege that the scores obtained by them were, and I quote, unlawfully reduced and added by the first respondent to the scores of the second respondent, unquote. They failed to state their scores that were reduced and added to that of the second respondent by the first respondent, and the figures that shows that the first petitioners won the election. In paragraphs 72, 73, 76 to 78, where the petitioners allege overvoting, they merely stated that they will, and I quote, rely on the forensic reports of the election materials showing that the votes cast in the polling units in Ekiti State, Oyo State, Ondo State, Taraba State, Osun State, Kano State, Yobe, and Niger States exceeded the number of votes accredited on the beavers in those states. Petitioners failed to specify the polling units in those states where the overvoting occurred, the number of votes affected, the margin of lead, which they claim that the voters who ought to legitimately vote in those polling units. In paragraph 73 of the petition, petitioners only stated that they will, and I quote, show that in the computation and declaration of the results of the election, based on uploaded results, the votes recorded for the second respondent did not comply with the legitimate process of computation of the result and disfavored the petitioners, unquote. In Rivers, Lagos, Taraba, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, and Plateau, and other states of the Federation, petitioners neither specified the uploaded results nor the votes illegally recorded by the second respondents and how they were disfavored. In paragraph 83 of the petition, where the petitioners claim that the first respondents scored the majority of lawful votes cast at the election, they did not state the majority of lawful votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on Form EC8As to establish that substantial votes were unlawfully credited to the second respondent, they failed to state the figures of the unlawful votes credited to the second respondent. In the petition, the petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. Rather, petitioners only stated that they will rely on spreadsheets, inspection reports, and forensic/expert analysis, which they say they have incorporated in the petition by reference. But none of the spreadsheets, inspection report, and forensic/expert analysis was attached and served along with the petition on the respondents. Rather, they were only listed as items 35 and 36 in the list of documents to be relied upon by the petitioners. It is only in paragraph 62 and 64 of the petition where the petitioners allege that the first respondents suppressed the lawful votes of the petitioners and inflated the votes of the second and fourth respondents in Rivers and Benue states. That the petitioners gave figures of the votes, where the petitioners gave figures of the votes suppressed for the petitioners and those inflated for the second and fourth respondents, and also stated that they claim to be the actual figures scored, what they claim to be the actual figures scored by them and by the second and fourth respondents. But all other paragraphs of the petition where irregularities and malpractices were alleged are bereft of any material details of the polling units or places where they were alleged to have taken place, or the figures of votes alleged to have been suppressed, inflated, or inflated. It is also pertinent to observe that in paragraph 79 of the petition, where the petitioners allege corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance to be in support of their allegations of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practices, while standard of proof of non-compliance is on the balance of probabilities, that of corrupt practices is beyond reasonable doubt. See PDP, INEC, Mohammed Wamako, Board of Customs and Excise versus Alhaji Ibrahim Barrow, citations on the record. It is instructive that in paragraphs 3.2, 3.21 of their submission, in opposition to the first respondent's objection, the petitioners appear to have considered that in the averments of the petition, they have not specified the particular polling units where the alleged irregularities and malpractices occurred, or specified the figures of the votes or scores which they are alleged to have been suppressed, deflated, or inflated. Rather, they stated that the details of the polling units are contained in the spreadsheets, and forensic analysis reports which they have incorporated and made part of the pleadings by reference. See particularly on this paragraph 67 of the petition. Petitioners further argued that since the respondents have failed to apply for further particulars under paragraph 17(1) and 2 of the first schedule to the Electoral Act, they are deemed to have understood those amendments. However, by paragraph 15 of the first schedule to the Electoral Act 2022, when the petitioner claims, and I quote, that he had the highest number of valid votes cast at the election, the party defending the election or the return at the election shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has a first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as a winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes in support of his claim that he scored the highest number of valid votes that a respondent will then have a duty to object to any part of the particulars of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be referred to in the pleadings, but it must also be included as part of the pleadings to be served on the adverse party, so as to enable the adverse party to properly respond to same in his defense. Indeed, in all the cases of EFCC reign, Ekpomo Polo versus Edere Moda, Marine Management Associates Incorporated versus NMA, and Dinjadi and Omako Supra, which were relied upon by the petitioners, the documents which were incorporated as part of the pleadings by reference were served along with the pleadings on the adverse party. In considering a similar scenario, this court, per Ayola, JCA, as he then was, held in Nigeria Merchant Bank PLC versus Ayedun Investment Limited as follows, and I quote, "Before I part with this appeal, it is pertinent to advert to one pleading question raised in this pleading in regard to the consequence of a party pleading that he will rely on certain unspecified documents at the trial. The plaintiff contended that such arguments made the contents of such document part of the pleading. In this case, the plaintiff in paragraph 30 of the statement of claim pleaded thus: the plaintiff at the trial will rely on all letters and documents between the parties pertaining to this suit. Although the principle is established that if an agreement in writing is referred to in a pleading, it becomes part of the pleading, and it is open to the court to give the agreement its true legal effect, irrespective of the term used in the pleading to indicate such effect, that proposition of law should not be used to cover such argument as shown above, which lacks specificity. Besides, a report such as Exhibit P22 in this case, prepared by a witness for the plaintiff and tendered at the trial by the witness, cannot be described as documents between the parties pertaining to the suit. At the appropriate time, when the occasion arises, the true ambit of the proposition of law in such case, such as Bank Genesis versus Petai Limited, ought to be defined, unquote. In the instant case, the spreadsheet and forensic report, which were documents prepared by the petitioner's witnesses, were not served along with the petition on the respondents, but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4 sub 5 sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of the petition, unquote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence during trial. Contrary to the petitioner's argument, it does not cover incorporation of documents into pleadings by reference. It is also noteworthy that the spreadsheets and forensic reports which the petitioners claim to be incorporating into the petition by reference are actually documents prepared by the petitioner's witnesses. In other words, the spreadsheets and forensic reports are not documents which are outside the control of the petitioners and which they have to obtain by subpoena. Being the petitioner's own documents, they ought to have served those documents along with the petition on the respondents, so as to enable the respondent to counter same by engaging their own experts to appropriately respond to same if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents, having joined issues on the general allegations contained in the petition, they are deemed to have understood same. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, Gungumiju Jesse, as he then was, now JSC, held in Udiaga and another was Omegara, as follows, and I quote: "The argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort to pinpoint in the pleadings the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, massive thumbprint of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? The arguments in the appellant's pleadings should have contained details of the allegations and complaints to which the respondents could reply in detail in their own pleadings. Appellants expected the respondents to reply to the various specific allegations contained in the witness statements filed along with the petition. That is not the correct procedure. Those specific allegations should have been in the pleadings. The pleadings must show the facts disputed, while the witnesses would give evidence of these facts. In election petitions, it has been held that there is the need for particulars where required in order to prevent taking adverse party by surprise. It is not the function of particulars to take the place of necessary arguments in pleadings, unquote. Indeed, in a presidential election like the one being challenged in this petition, where it was held in 176,846 polling units, 8,809 wards, 774 local government areas, 36 states, and the Federal Capital Territory, it is unimaginable that arguments in the petition which merely allege irregularities and/or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper, merely because the respondent has not requested for further particulars. Sibel Goria Ahmed and PDP are named. More so, when an election petition is by nature a declaratory action, in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the respondent. Ibusari versus Adepoju, Oyetola versus Adeleke, and Anazong versus Onubogu, citations on them. It is in this respect that a petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of a party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enang and others versus Adu. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, collation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed, are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of paragraph 4, sub 1, sub D of the Electoral Act 2022. In accordance with paragraph 4, sub 7 of the said schedule, the said paragraphs are consequently hereby struck out. On the first respondent's prayer to strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition, the essential contention of the first respondent is that whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court, petitioners have in paragraphs 65, 67, 70, and 71 stated that they will rely on the report of the inspection. Additionally, the first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in substantial compliance with the Electoral Act 2022. They have also alleged that they have scored majority of lawful votes cast and should be declared the winner. Relying on some cases which are produced here, the first respondent urged the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5 sub 1 and sub 2 on the other hand for being inconsistent. Conversely, the petitioners contend that the law allows them to plead conflicting facts insofar as they have claimed alternative reliefs. They referred to the alternative reliefs at pages 35 to 37 of the petition and relied on some cases which are reproduced here, as well as the ruling on similar objection by the 2019 Presidential Election Court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition, which I have reproduced at the beginning of this ruling, are undoubtedly sought in the alternative. The settled law is that reliefs can be sought in the alternative, and where so sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In Adigije versus Mwaugu and others, this court, Ogun Wimiju Jesse, as he then was, held that, and I quote, in civil litigation and indeed in election matters, a party can make two seemingly contradictory pleadings, leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance and in the same breath claim that he won the election by a majority of lawful votes. Petitioner may plead the same set of facts to ground alternative relief. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief as the party must decide which relief is best supported by the evidence on record, unquote. See also on this Metal Construction West Africa Limited versus Aboderim, citation given. In any case, the first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition wherein petitioners averred that the first petitioner was duly sponsored by the second petitioner, on whose platform the first petitioner contested the vote. I therefore have no hesitation in discountenancing this ground of the petition. Now, second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. The second category of the respondents' applications that challenge some of the grounds of the petition and or the competence of the petition are as follows. First, respondents' motion filed on the 19th of April 2023, seeking 1. Order striking out ground 2, paragraphs 33 to 79 are reliefs 5, Roman 1 and 2 of the petition on transmission of election results for being cut off by issue estoppel. 2. Order striking out paragraphs 20, Roman 1, 21, 23, 24, 25, 26, and 27 on nomination of the second and third respondents for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out reliefs 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition. The above two motions are predicated on several grounds which are reproduced herein. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2022, and the plea of estoppel in relation thereto, as well as the issue relating to competence of the reliefs sought in this petition, are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in the petition. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in substantive case. Nwanko and others versus Eradua. Ocholi on Onojo James, SAN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's local standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, the respondent's replies, or to some paragraphs of the petitioner's replies. lack of local standi of the first petitioner. The second and third respondents and the fourth respondents in their motion filed on the 8th of May 2023 also objected to the first petitioner's local standi to bring this petition. The principal contention is that the first petitioner was in contravention of Section 77 sub 3 of the Electoral Act 2022. They argue that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022, joined the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members of the second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by Section 77 sub 3 of the Electoral Act 2022. And since the first petitioner is not in the membership register submitted by the first respondent to the first respondent by the second petitioner, the first petitioner lacks the local standi to challenge the outcome of the presidential election. By contrast, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned, and the courts lacks the jurisdiction to entertain them. They relied on the cases that are reproduced here. The courts have consistently held in a plethora of cases that the issue of membership of a political party is an internal affair of the political party. It is not a justiciable issue, and courts have no jurisdiction to entertain it. Say Enang versus Asukwo, others, Sani and Galadima, and Tumbido versus INEC, citations on the record, as well as all the cases cited above by the petitioner. The provision of Section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, the first petitioner has satisfied the requirement of being a member. The second petitioner, as provided for in Section 131 sub C of the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership, second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. First respondent in his motion of 19th of April 2023, and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, the petitioners who came third in the presidential election are seeking to be declared the winners of the election. The petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks the jurisdiction to entertain the petition as constituted. It places reliance on JJD and INEC. Buhari and Obasanjo, citations on the record. No position, however, petitioners relied on the cases of Obasanjo and Eradua, Buhari and Yusuf, Akpoti and INEC, and contended that only statutory respondents provided in Section 133 of the Electoral Act 2022 are necessary parties to the petition. And the petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic Party. By Section 133 of the Electoral Act 2022, the statutory respondents in an election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct is complained of. In the cases of Obasanjo and Eradua and Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties to an election petition. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing, is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate two or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of Jegede and INEC cited by the first respondent is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution, would have ceased being a governor of Yobe State if the case made out in the petition that he could not combine the offices of governor of Yobe State and acting chairman of the All Progressive Congress is sustained. In this case, Abubakar Atiku and the People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition, and the petitioners herein have no obligation to join them in this petition. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. Also, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CAPEPC 05-2023, which, as mentioned in the earlier part of this ruling, this court has consolidated with the petition in line with paragraph 50 of the first schedule to the Electoral Act 2022. This ground of the objection to the competence of the petition is unmeritorious. It is accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the reliefs which the court can grant in an election petition are statutory, as provided in section 136, sub 1, sub 2, sub 3 of the Electoral Act 2022. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply, the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41 of the petitioner's reply for offending the provisions of the first schedule to the Electoral Act 2020. Second and third respondents' motion filed on the 13th of May 2023 seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath with failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply, the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply, their respective replies, or in the alternative, the paragraph thereof, which they have variously listed above. Their essential contention is that the replies, or in the alternative, the paragraph thereof, have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or a mere repetition or a hash of the facts contained in the petition, contrary to the provisions of section 16, paragraph 16, sub 1, A and B of the first schedule to the Electoral Act 2020. Respondents replied on several judicial authorities, which are reproduced. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification of the second and third respondents, as well as the non-compliance by the first respondent to the Electoral Act 2022. They relied on Silva and INEC, PDP versus Ezo citations on the record, and urged the court to discountenance the objections of the respondents and uphold the petitioner's replies. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, the petitioner's reply in answer to the new issues of fact. So, however, that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds or prayers tending to amend or add to the contents of the petition filed by him, unquote. By the import of paragraph 16 sub 1A of the first schedule, the petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not in so doing amend or add to the petition. It is instructive to observe that the words used in paragraph 16 1A are, quote, new facts, grounds or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of a petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Njadi and Wamako, Adepoju versus Awoduyilemi, and Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, a new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new to the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time in the statement of defense by the defendant. The new issue, in both its contents and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff, and that does not bear the name of a new issue in law. A new issue arises where the plaintiff did not avert to or touch the contents of the defendant's averments in anticipation. The defendant's averment was introduced to pleadings for the first time and therefore unique and novel to his pleading, unquote. A careful examination of the petitioner's petition, the first, second and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, petitioners also introduced new facts in their replies to the respondents' replies which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A of the first schedule to the Electoral Act 2022. Paragraph 16, 1 to the law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in their petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by Section 36(5) of the Constitution of the Federal Republic of Nigeria, 1999. Since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP and another versus INEC, others. Maku and another versus Al Makura and other citations on the record. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraphs has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition. It is only a response to paragraph 7